Well, good morning, everyone, or good afternoon, good evening, depending on your time zone. First of all, on behalf of the Stanford International Arbitration Association and of Stanford Law School, I would like to thank you all for attending this event and to say a special thanks to our guests, who I will very briefly introduce. And I'll begin with Hugh Carlson, one of the members of our arbitration tribunal, because I truly, Hugh, want to express my gratitude for all the support that you've been given to the Arbitration Association throughout this year, including this event, which would not be happening without your support and your ideas. Hugh Carlson is the CEO of Three Crowns, in which capacity he is responsible for its global operations. He is listed in leading rankings and directories and has been described in Who's Who Legal as an absolutely phenomenal and commanding the respect of his peers. He teaches at Harvard Law School, could be teaching at Stanford, who knows? Hopefully, one day we'll have him with us as well. And he co-founded his own international arbitration workshop. Prior to school, he was a software engineer. And when the closest thing to AI might have been the Microsoft Assistant in Clippy. So, yeah, alongside Hugh in the arbitral tribunal, we have Sophie Nappert, which will be our presiding arbitrator today. Sophie is an arbitrator, an independent practice based in London, and she's a pioneer practitioner at the intersection of arbitration and legal tech. She recently completed a program on blockchain strategy and co-founded ArbTech, which is an online community forum that fosters cross-disciplinary dialogue on technology, dispute resolution, and the future of justice. Our third arbitrator is also an expert in technology and dispute resolution, Claire Morel de Westgaver. I'm sorry if I didn't pronounce that correctly, Claire. Please correct me if it's wrong. Claire is a partner based in London at Brian Cave Linton Paisner. She has a lot of experience with disputes involving technology and cybersecurity issues. And she's also a board member of the Silicon Valley Arbitration Mediation Center and a co-founder of the award-winning initiative Mute Off Thursdays. Last but not least, she sits on the ICC task force on the use of information technology in arbitral proceedings and on the advisory board of CyberArb. Turning to our debaters today, we have Christel Tham, a member of the Bevois International Dispute Resolution Group in New York. She will be arguing for the motion, so she will be defending the fact that advances in artificial intelligence will substantially disrupt the practice of law in the next 5 to 7 years. And opposing to the motion, we have Sofia Klot, a member of Freshfields Dispute Resolution Group, also in New York, and she will be arguing, as said, against the motion. The idea will be to replicate a bit of hearing, including time allocation and questions, so this will be fully in the hands of the arbitral tribunal. And before we go to the event, I would just make a short disclaimer. The debate aims to be purely academic, and nothing that is said here, either by the debaters or by the members of the arbitral tribunal, necessarily reflect their views or the views of their firm. In fact, the advocates were assigned their signs by our team. I'll stop talking and swear, but one last introduction. Professor Tom Rubin will be taking care of the real opening remarks. He's a lecturer at Stanford Law School and a strategic advisor at OpenAI, having served for many years as Microsoft's Chief Intellectual Property Strategy Counsel and the head of copyright, trademark, and trade secret at a company. He will hopefully give us a taste of the hot topics that are being debated at the Silicon Valley right now. Honestly, since ChatGPT has been released, is all that we talk about here. So, Professor, please, you have the floor.
I'm sorry. I'm so sorry. abusing my role as a chair. Marina, please tell our audience what the format will be, how long every participant will speak. Thank you.
Oh, sure. Sorry. So, Professor, we are going to be flexible with time, but Professor Tom Rubin will speak for about 10 minutes, and after that, we will move on to the debate. The debate was initially, we initially agreed upon that it would be 10 minutes for the claimant, 10 minutes for the respondent, and then 10 minutes for reply, and 10 minutes for rebuttal. But I mean, you are the presiding arbitrator, so please feel free to take full control on this, to grant extensions or be more flexible on time. I mean, you are in charge here.
Thank you very much. I'm sorry, Professor.
Thank you, Marina, and thank you to the Stanford International Arbitration Association for hosting what's certain to be a lively debate this afternoon, and for inviting me to give a few brief opening remarks. It's a pleasure to be here with you all today. My name, as you've heard, is Tom Rubin, and I'm a longtime lecturer here at Stanford Law School. Over the past several years, I've taught seminars on a wide variety of technology policy issues, including artificial intelligence, data, privacy, intellectual property, and antitrust in digital markets. Before we talk about technology, I'd like to say a few words about arbitration. Like many on this Zoom, I had the privilege of attending law school at Stanford, but it was back at a time when alternative dispute resolution, much less international arbitration, had less prominence than it does today. As a young lawyer, after clerking in the Southern District of New York and on the Second Circuit, I started my career as an associate at Debevoise and Plimpton in New York, where I'm pleased to see that one of today's debaters also practices. And at Debevoise, I was very fortunate to work closely with two of the leaders in the field of international arbitration, whom I suspect some of you might have known or know, Robert von Meren and Donald Donovan. In fact, fresh off my clerkships, Robert asked me to work with him on a significant international arbitration, as to which he served on the panel. Though today we're talking about AI, the subject of that arbitration actually involved one of the leading technologies of its day, which was nuclear power plants. The dispute was essentially between Westinghouse Electric Corporation and the Republic of the Philippines, and it involved claims at the time, which was in the early 90s, that seemed astronomical, $1 billion. The Philippines and its National Power Corporation claimed that Westinghouse and its contractors' contracts for the construction of the nuclear power plant were procured by bribes paid to then President Ferdinand Marcos and his associates. They also alleged that the constructed plant was defective and unable to be operated safely. It was a fascinating matter to work on. I was essentially the law clerk to the panel, and it involved what at the time seemed like an enormous record. But it was a thrill at that early stage of my career to work closely with and learn from Robert. The matter had all of the elements that make the practice of international arbitration so rich: significant procedural issues, critical substantive issues, very high stakes, and lots of intrigue. From there, I went on to become a more traditional litigator. I served as an assistant United States attorney in the Southern District in New York, and more recently was special counsel at Quinn Emanuel. But using this event as an opportunity to look back at that experience, I have to say that it was refreshing that the dispute was handled through arbitration and not litigation, so that it was relatively free of the posturing and churn and inefficiencies that can mark litigation. And as Robert schooled me early in my career, it enabled the parties and the arbitrators to focus on the actual issues in dispute. So I dedicate my brief appearance here today to the memory of Robert von Meren. May all of you entering the field have a career as meaningful and important as his was. So now, turning to the precise subject at hand, AI and the practice of law, allow me to spend a couple of minutes sharing some brief thoughts. Though I've spent time during my career as a litigator, I really am a technology lawyer. By that, I mean I've dedicated my career to the development of cutting-edge technology and to the corresponding development of sound law and policy governing its use. I've been involved in these issues from a variety of perspectives, and I mention them here because I suspect that some of the issues that the debate today will focus on will implicate the various perspectives from which AI may disrupt the practice of law. After Debevoise and Plimpton, I was honored to serve as an AUSA, where as one of the very first federal prosecutors of criminal and electronic crimes at the early stages of the commercial internet. Given the relatively meager resources of government and the critically important role that it plays in the legal system, it will be interesting to hear how AI might be deployed in and disrupt that sector. At Microsoft, where I served as Chief IP Strategy Counsel for many years and where I started working on AI issues with Microsoft Research as early as 1999, I saw the different perspective of being a client, much less a huge corporation with an enormous number of emails, records, and documents that could be implicated in any given dispute. Microsoft was also at the forefront of corporate efforts to rein in outside counsel legal expenses using a variety of now well-established methods. I look forward to hearing about perspectives on how AI might impact the practice of law from the in-house perspective. And finally, as I mentioned, I spent 6 years at Quinn Emanuel, which in some ways may be the epitome of big firm, big litigation. I look forward to the perspectives on how AI may disrupt that world too. Finally, a word about AI itself. When I was at Quinn Emanuel, I was outside counsel to a once relatively unknown AI company. And for the past 2 years, as you've heard, I've served as a strategic advisor to OpenAI. Of course, I'm here today as a lecturer at the law school and not on OpenAI's behalf. But having been so deeply involved in the development of the technology and its deployment, I'm eager to hear the thoughts of the participants today. You are all well aware of the incredible power and excitement, both good and understandably mixed with some trepidation, generated by the technology. It is advancing at a rapid pace, even in the field of law, as demonstrated by some specific benchmarks. To cite just one example, when ChatGPT was released last November, it ran on GPT 3.5. Just a couple of months later, a more sophisticated model, GPT-4, was released, which gave researchers the ability to compare the extent of improvements between those two generations. After its release, Daniel Katz, who's a professor at Chicago-Kent College of Law, put GPT-4 to the test by having it take the bar exam. Now, GPT 3.5 had performed poorly, having scored at 50%, which placed it in the 10th percentile. Not a lawyer I know would want to hire GPT 3.5 as co-counsel. But GPT-4, however, did remarkably better. It scored a 75%, which compares to the average human score of 68%, which placed it in the 90th percentile. Not so bad. For those of you who want to compare your own transcript to that of GPT-4, you should know that it did particularly well in the subjects of contracts and evidence and trailed in civil procedure and torts. Earlier this week at a Goldman Sachs event in San Francisco, Bill Gates, who's not a bad prognosticator of technology, gave his own thoughts about the future impact of AI on everyday technologies that we've all grown to use over the past 25 years. What he said was this: you will never go to a search site again. You will never go to a productivity site. You'll never go to Amazon again. So will the disruption be as significant in the field of law? I look forward to the debate. I'll state only one thing with certainty. Whatever AI's abilities are today, they will get better tomorrow. Now, on to the main event.
Thank you very much, Professor. That was great. I will then pass the word to, if the members of the Arbitration Tribunal want to say anything ahead of the debate, please feel free to do that.
So I have been nominated unilaterally as chair, so it's my pleasure to chair this tribunal. I don't know if Hugh or Claire would like to say anything before we start. Please, Hugh.
Nothing from me. Thank you, Sophie.
Claire? You have views on this. We're going to keep them for later. Fantastic. Okay, please. So as we've heard, it is 10-minute segments. So if we can hear first, 10 minutes for the prop. I'm going to keep time just so we have an idea where we're going. But obviously, if you're in the middle of a sentence, I'm not going to cut you short. Just to give you an idea where we are. Please start.
Thank you, Madam Chairperson, members of the tribunal. It's a pleasure to be here today and to address you on this particularly timely topic. I want to start by saying that if we consider the three key factors that would determine the impact of AI advances on the practice of law, that is, the technology, the potential users and their adoption and acceptance of said technology, and the regulatory framework, then it becomes evident that advances in artificial intelligence will not only change, but substantially disrupt the legal industry in the next 5 to 7 years. And let me explain. First, the technology. The advances in AI technology that we're seeing today will substantially disrupt the practice of law because they're advances not just in degree, but in kind. And it's specifically generative AI and the use of large language models that will be transformative for our profession because it allows the machines to operate in the medium by which humans, and especially us lawyers, communicate, think, and function, and that is language and text. We can now process extremely large amounts of text quickly and accurately and identify relevant information, inconsistencies, potential risks. The models can be trained through user feedback in the form of simple text. No more complicated searches using Boolean operators. And perhaps most critically, it can generate creative output including complex and sophisticated text in various forms. So no more staring at a blank page with a blinking cursor, wondering how to translate the massive amount of information that you just read into a few pithy paragraphs. This novel ability of machines to operate not via a complicated coding language, but through actual language, translates into massive efficiency gains in almost all time-sensitive legal tasks through the life of a litigation or arbitration. This includes reviewing documents for privilege or relevant information, conducting due diligence on legal research and reviewing case law, performing contract and legal document analysis, to name a few. And for a profession in which we literally bill by the hour, these efficiency gains alone will substantially disrupt the practice of law. The need for legal assistance will significantly diminish. Law firms might need to rethink the billable hour and possibly bill by the task. With less time spent on these time-consuming tasks, lawyers' value add will be in strategizing, reasoning, considering the ethical perspective, and performing high-level thinking. We'll need to learn new skills, such as knowing how to choose the right AI tool for a particular task, to construct the right queries, evaluate the relevance, quality, and accuracy of the responses, and synthesize the overall results into a cohesive, actionable picture. The very nature of our jobs as advocates will change. Moving on to the second factor, potential users. Now, the legal profession is known for being inherently conservative, but counsel, judges, arbitrators, and clients already are and will continue to accept, adopt, and demand the use of AI technology in their work because the benefits are just too transformative to ignore, and anyone that fails to capitalize on them will be at a disadvantage. Law firms, for example, will be unable to remain cost competitive, lose clients, and undermine their ability to attract and retain talent.
Can I just chime in with a quick question?
Please.
As a matter of definitions, looking to the motion, we see that we're to evaluate this on the basis of whether there will be substantial transformation. How do you define that? Is it sort of a Justice Potter Stewart formulation of we know it when we see it, or is there some type of metric or threshold, like the number of associates versus partners, something like that, that we should be considering when we're evaluating whether or not the motion's been upheld?
Thank you for the question. I think I specifically avoided getting into definitional questions like that because I think it is hard to look at specific parameters given the diversity of the practice of law. The motion itself is even broader than simply just looking at arbitration, but the practice of law. And that is the reason why in describing the impact of the technology, my focus was on the efficiency gains and the ability to function in the same medium that lawyers use to communicate and analyze and perform their work. And I think it's the elemental nature of this change that will result in the disruption that will be substantial. And that's also why the focus was on the three factors of technology, the users, and the regulatory framework, each of which will interact with each other and create this multiplier effect, which will then, in the next 5 to 7 years, cause this disruption. And the disruption will be significant because people will adopt these improvements, and the benefits are just too transformative to ignore, including time and cost savings that in turn can enhance the quality of legal services, greater access to justice and fostering greater diversity by reducing barriers such as high costs, time-consuming procedures, and language barriers, and even enhance decision-making through valuable data-driven insights that can lead to better outcomes and increased satisfaction with the process. And there's no need to look into the crystal ball. There already is evidence of this disruption. The future is already here. And AI technology, including generative AI, is already being deployed throughout the practice of law. Law firms such as Allen & Overy and DLA Piper are already using custom generative AI tools built on GPT-4, such as Harvey AI and Casetext Co-Counsel, to conduct research, due diligence, and perform the tasks of a legal assistant. A judge in Colombia used ChatGPT in his opinion about a dispute over medical coverage with a health insurance company. He used it, quote, to optimize the time spent drafting judgments after corroborating the information provided by AI. In the US, judges are relying on COMPAS, an AI-powered software that uses an algorithm to assess potential recidivism risk to determine bail and parole cases. And this use is only going to increase in the next 5 to 7 years. There's apparently already a long wait list for firms anxious to deploy Harvey AI in their practice. More and more law firms are appointing chief innovation officers in recognition of the importance of employing AI technology. Google and Microsoft are already incorporating AI into all of their products in such a way that it will be hard to avoid. And because the technology is so groundbreaking, and because the users are already and will continue to increasingly adopt and accept the technology in the practice of law, the regulatory framework will have to adapt to these changes, which brings me to the third factor. As a preliminary matter, there does not appear to be any blanket ban on the use of AI generally, much less in the practice of law. And it does not look likely to happen anytime soon. Instead, there has been a rush to develop coherent regulations on AI. And in the few laws or draft laws that have recently emerged, we see them not banning the use of AI outright, but sensibly regulating its use in a way that allows us to reap its many benefits while ensuring its consistency with the principles of transparency, confidentiality, non-discrimination, privacy, and other public policy objectives. In the US, the states that have enacted and adopted regulation governing AI use focus on consumer protection, such as prohibiting the use of a chatbot to incentivize the sale of goods, or the elimination of bias or discrimination, such as prohibiting using AIs to make hiring decisions. The EU's proposed AI Act, which operates on a risk-based approach, would propose to regulate generative AI tools in a similar way, including through the disclosure of copyrighted material used to develop their systems, testing and mitigating reasonably foreseeable risks. And in the litigation world, there's not been much direct regulation of AI use yet for obvious reasons, but the law will have to catch up soon with reality, given how law firms and courts are already using AI, as I've mentioned. In the example of using COMPAS, the Wisconsin Supreme Court was recently confronted with the question of whether such use violated a defendant's due process rights when the sentencing court relied in part on it to deny a defendant possibility of parole. And the court found that it did not violate the defendant's due process rights. In the arbitration world, because of arbitration's party-driven nature, arbitral rules will also likely adapt to accommodate the use of AI in international arbitration. And we've already seen this with the use of video conferencing during the pandemic or the use of third-party funding in arbitration, we saw the major arbitral institutions all swiftly amend their rules to address these developments. And that is because contractual freedom and the parties' ability to choose the procedure are key tenets of international arbitration.
Ms. Tham, if I may, I'm sorry to interrupt. Your argument, it strikes me, is premised on a big efficiency tenet. But efficiency, of course, of this technology also must factor in accuracy. And AI has certain weaknesses in that arena. And I wondered if you could address us on that.
Of course, Madam Chairperson, I'd happily do so. 2 points to that. First, as Professor Rubin already pointed out, the rate at which the technology is improving and advancing is unprecedented. And so to the extent that there are weaknesses and limitations to the technology, they are going to be improved upon and corrected very swiftly. And secondly, the efficiency gains that I referred to when discussing the use of AI technology in the practice of law are efficiency gains with respect to a specific genre of tasks. And by this, I'm not referring to decision-making or the adjudicative process in the life cycle of litigation on arbitration, but sort of the rote tasks, contract review, document review, reviewing case law. And these tasks, and it's about the time and cost savings that can really generate this change for law firms and the practice of law that is undeniable. And yes, that might still require associates or partners or lawyers to review the ultimate results, but that delta, that time saving, is still undeniable regardless of these limitations.
I think you're right about document review, and but I was this is technology that is groundbreaking insofar as it can help with legal research, and it's also technology that, as we know, makes things up as it goes along. And I wonder if it cannot send associates, especially younger associates, on a path that is wasteful of time and cost. And I wondered what you had to say about that on your case.
Yeah, I think it's very new technology, and that is also why I said that as lawyers, we would need to develop new skills in terms of how to manage these new AI tools. I think it depends on the tool. I think it depends on how it's being customized, such as right now, for example, Harvey AI is in consultation with different law firms, and I think it's a custom tool being developed for each law firm according to their needs. And us lawyers, being conservative, typically do not jump into things head first without thinking and considering the implications of the use of such technology and building safeguards around its use, such that any risks, if they do exist, are clearly identified, made clear, and mitigated to the extent possible. At the end, AI is going to be a tool, and it's a question of how this tool will change our practice and whether that change is substantial. And the main point here is that it is the time and cost savings that used to take up such a large amount of time in our practice that will then suddenly create a whole amount of space elsewhere for us to focus on other areas, generate more creativity, develop new skills, and focus on the aspects of our job that currently cannot be replaced by artificial intelligence.
Would you agree with me that it has the potential of turning lawyers into prompt engineers, i.e. the ability to ask the right question to get the right output? And as a second question, I would say, how much do you trust human nature to draw a line under what you can ask ChatGPT to do or whatever other model, and what you cannot ask it to do if you're under the cosh and under time pressure and you need to have an answer quickly to a difficult question?
So to your first point, I think I'd argue that we already are prompt engineers as lawyers in terms of how we learn how to ask clients questions about their matters, how to cross-examine a witness, how to put in a particular search query into Westlaw or LexisNexis using Boolean operators to figure out and generate cases that would be relevant for our search. I think we are already prompt engineers, and this is just a different method of doing that, and in a way that will massively enhance our efficiency. In terms of drawing a line and the question of ethics, I just want to emphasize again that the motion of today's debate is whether artificial intelligence will disrupt the practice of law or not, whether it should. It's not a normative question. It's a question of whether it will happen. And I think it's precisely because of human nature and our general urge to use a sort of path of least resistance and use the tools at our disposal that artificial intelligence will be taken up because its benefits are so massive. Whether that's good or not, whether that will result in issues and raise ethical questions, I think as lawyers, we already have a professional code of conduct that applies, and the rules that are contained in that code of conduct similarly guide our practice, whether or not AI is being used.
Counsel, if I may.
Can I interject?
Go ahead.
Mrs. Tham, I'm very happy to raise the issue of
Arbitrator Morel,
Claire, there's a sound issue with you. I don't know if it's your microphone or you sound very far away in the land of AI.
Let me just try to. Is that better? Not so much. No?
Yes, that's better. Yes.
Okay. I think earlier you mentioned that that the algorithm or the AI tool that we're talking about here in the abstract would consider ethics when making a decision. And when you talked about the benefits of AI, you talked about time, cost, quality, access to justice, enhancing decision making based on data. But as lawyers, we have duties. We have duties to the courts, to our clients. And I was interested in your point earlier that, you know, when you suggested that the algorithm would also take ethical considerations. Could you expand on that a little bit?
I'm sorry, I think I missed the last bit. So the question is how AI can take into account ethical considerations? Sorry, if you could repeat that question.
That's correct. I think you mentioned that earlier, so I wanted to understand what you mean by that.
So my point here is that regardless of my point here is that professional ethics rules already limit what lawyers can or cannot do regardless of whether AI is used, and those should still be adhered to and guide attorneys' use of AI. Whether AI exists or not, there will always be the bad eggs out there that commit certain acts that result in them getting disbarred or commit unethical practices. But the model rules of professional conduct still require us attorneys to protect the privacy and confidentiality of client data, competently and diligently represent our clients, which would then mean that we wouldn't be able to simply blindly rely on AI-generated outcomes and have our clients suffer the risk of hallucinations, of false impressions of sentience. We would need to make a reasonable inquiry before making a representation to the court or the judge. And I would say that even the use of AI itself is arguably an ethical practice. The ABA model rules of professional conduct themselves require that lawyers be competent and keep up with new technology, so that they, and on behalf of their clients, can reap the benefits associated with the relevant technology.
So when counsel acts, for a client, let's say they need to act in the best interest of the client, and they also have a duty to not to misrepresent facts to the courts. If a lawyer decides to use AI to formulate a piece of advice, do you think that piece of advice will automatically take those two duties in consideration? Would that advice be in the best interest of the client, and would that algorithm that generated that representation to the court, will that algorithm take their duty to not misrepresent facts to the court? This is the ethical, kind of consideration I was referring to.
Yes, absolutely. And large language models and artificial intelligence, they function on the basis of probabilities, and the machine itself is amoral and doesn't have the ability to apply ethical rules. And that is why the role of the lawyer will evolve with the adoption of AI technology in our practice. It will become a key aspect of our jobs in incorporating the use of AI, to be conscious of these risks and to take the relevant safeguards and mitigating acts to ensure that our responsibility and duties towards our clients are properly met. And that actually brings me back to this point about regulatory framework and the development of these regulations that can help mitigate and avoid these situations from arising. And it's in fact the development of these AI-related regulations that would mutually reinforce the adoption of AI, because the more rules that are created around the use of technology, the more awareness, the more understanding of the technology and the practice of law, the more parties will feel comfortable actually using it and realizing, okay, when there's this piece of advice generated by artificial intelligence, I can't just take it, at least for now, on its face. I will have to review it. I will have to verify its accuracy. I would need to look at it from the ethical perspective. I would need to ensure that the substance of the document that I subsequently present to the court on behalf of my client is something that I, as a lawyer, can stand behind ethically and substantively. And I think the rules will be a big part in ensuring that, because these rules recognize, regulate, and legitimize the use of artificial intelligence. And the greater the adoption, the greater the disruption.
Counsel, if I may, just on the regulatory piece, I'm glad that you returned to this. I think earlier you noted that there hadn't yet been any bans. And even if the tribunal is sympathetic to the possibility of AI transforming the legal industry, there's a question of permissibility. And we've already seen within the opening weeks of ChatGPT being launched that it was banned in Italy. Shortly thereafter, at the European Union level, there's a European AI Act, which, and others better placed on this will probably be able to speak to it in more detail. But I understand that it would heavily restrict the use of AI in the judicial system. Across the pond in the United States, there are rumblings that there would be similar legislation introduced here, not only for privacy concerns, but also coming from a place of populism. So when looking at how quickly the landscape is shifting against the adoption of AI, and when considering that the legal industry and law firms more specifically aren't necessarily in the habit of taking risks that would place them at odds with the law, why are you as optimistic that in 5 to 7 years, law firms will have embraced AI such that it substantially transforms the industry?
So a few points in response. First, I mentioned that there were no blanket AI bans. The EU AI Act is a draft act. It's a proposal. It's not been implemented yet. And it's a risk-based approach. And it's only AI systems with an unacceptable level of risk to people's safety that would be strictly prohibited. And that's use of AI for social scoring and classifying people based on their social behavior. AI technology and the use of the practice of law would be classified as high risk because it involves the administration of justice. But it's not entirely clear, based on what has been proposed, that the regulations, as you say, will significantly restrict the use of AI in the practice of law. I think people are wary, but people are also very conscious of the benefits that it can bring about. And there certainly is no consensus with respect to how to regulate AI at this point, and it's precisely because of this tension. And with respect to the reticence on the part of the legal industry to adopt something that would be illegal, I mean, law firms themselves have already adopted artificial generative AI technology in the form of Harvey AI, Case Text Co-Counsel, and the mere fact, I mean, the fact that law firms are actually themselves already inherently conservative, coupled with the fact that they still are doing it. And keep in mind, ChatGPT was rolled out and released in November of last year. That's about 6 months ago. And large elite law firms have already adopted custom tools wholesale in their practice. In the situation of Harvey AI in particular, we know that they have in particular accounted for issues of confidentiality and ethics, in confidentiality in particular, because the custom tool is actually firewalled based on the firm. And so once that specific custom tool is trained for the specific firm, the model stays specific to that firm and is not used as a base model when deploying Harvey at different firms. And lawyers have thought through this. We have thought through the risks, not we, but some lawyers at law firms, and clearly lawyers are thinking through all the risks and still making that leap to adopt the tool in their practice. And this is just in the first 6 months of the deployment and release of the technology that's only going to get better and more accurate in the years to come. So if I may briefly...
Ms. Tham, you've been interrupted considerably. I'm going to give you 2 minutes to conclude if you take them.
Not at all. I very much welcome the questions, and I was actually pretty much at the end. So I just wanted to briefly conclude that because of qualitatively significant advances in artificial intelligence that I talked about, which are being and will continue to be adopted, accepted, and demanded by counsel, judges, and arbitrators alike, such that the regulatory framework must accordingly adapt and thereby mutually reinforce and support the responsible and more widespread use of AI technology in the practice of law. The practice of law will be substantially disrupted in the next 5 to 7 years. Thank you for your attention.
Thank you very much. If we can hear from the opposition, please.
Yes, of course. Thank you, Madam President. Let me see if I can share my screen since I have a presentation for you today. Here we go. I don't know if everyone can see it. Sorry for that. Okay, I presume that everyone can see my screen at the moment. If not, please let me know. And I will begin my presentation. So good afternoon, members of the tribunal. My name is Sofia Klot, and I appear before you today to argue against the motion Sorry, one second. It seems, I apologize, members of the tribunal. It seems that there is a problem with my presentation and it hasn't loaded properly. So, in the interest of time, I will simply do my presentation without support from the slides, if that's okay with the members of the tribunal. Okay.
Please go ahead.
Thank you. Let me start again. My name is Sofia Klot, and I appear before you today to argue against the motion. And the question before us today is whether advances in AI will substantially disrupt the practice of law in the next 5 to 7 years. And I want to emphasize this word, substantially. Now, picking up on Mr. Carlson's comment, the definitional elements in this motion are important. No one can deny that AI will have some sort of impact. The question here is to what degree and how long will that take? And we know that, and we need to determine what we mean by substantial. Now, substantial, the ordinary meaning of the term, is to a large degree. And admittedly, members of the tribunal, that doesn't give us a very clear indication. So I posted that the test that we should adopt to determine whether there is a substantial disruption to the practice of law is that we should ask ourselves whether 5 or 7 years from now, that when we look back on our jobs as lawyers or adjudicators, we find them to be completely unrecognizable. Or worse still, that we find that we have been replaced by a machine. So it's not really and merely a question of efficiency gains, as counsel on the opposite side proposed. It is a question of displacing work that can only be done by lawyers. Now, when we're talking about AI and its impact, it's very easy to get caught up in the hype. I want to cite here Roy Amara, a famous futurist and scientist, who said that we tend to overestimate the effect of a technology in the short run and underestimate its effect in the long run. This is what is known as Amara's law. And so, members of the tribunal, today I ask you to look beyond the hype and focus on the facts. And by facts, I mean what AI can actually do and what it cannot do. And this will serve as the basis to determine what is technologically feasible in the next 5 to 7 years. And anything else is really science fiction. Now, there are 3 reasons why our profession will not be revolutionized by AI in the next 5 to 7 years. The first reason is that AI is inherently limited, and this prevents it from being anything more than a productivity tool in the short term. The second reason is that legal professionals are, we could say, almost naturally risk averse, and are not inclined to embrace technological challenge. And the third reason is that there are economic incentives at play that militate against a fast embrace of disruptive AI. So let me start with the first reason, AI's inherent limitations. The AI that is being developed for legal practice today, which counsel on the other side referred to, comprises mostly either productivity tools or products which automate low value and repetitive tasks. Now, while some of these products are admittedly quite impressive, they will not displace adjudicators and lawyers in the short term, not even junior lawyers. What they will do is they will essentially allow us to keep doing what we already do, but much faster. During her remarks, my colleague, Ms. Tham, referred to some of these tools. I believe she referred to Casetext and to Harvey. All of these tools have something in common, and that is that they cannot understand or interpret legal documents or evidence. They can only draw statistical correlations from the data that they are fed to produce an answer that looks and sounds human. Let's take, for example, LLMs, large language models, such as ChatGPT, which has been at the center of the hype. I'm sure that the members of the tribunal are familiar with some of the problems plaguing these models. And Madam President actually alluded to one of those problems, the problem of accuracy. Hallucinations. These models have a tendency to make things up and present them as convincing and authoritative answers. And they also are not able to distinguish between the varying reliability of sources. And now I don't have to explain to this tribunal the importance that sources and citations have in our profession. But ChatGPT gives the same weight to an award penned by Professor Kaufman-Koller as to a comment on Reddit. In the practice of law, inaccuracies are a real problem with real-life consequences that can lead to liability. Another huge limitation is the lack of transparency. Now, you may have heard of the black box problem, which refers to artificial intelligence and ability to explain how it reached a particular conclusion in terms that a human can understand. But we as lawyers, we need to be able to explain to a client why we're proposing a certain course of action and be able to walk them through our thought process. And you, members of the tribunal, as adjudicators, you also need to be able to provide legal reasoning for your decisions. You can't just say to a party, oh, well, the AI told me that we have no jurisdiction. The entire system of administration of justice is built on legal reasoning, which is one of the cornerstones of due process.
Counsel, if I may just chime in. On the topic of accuracy, certainly the point is well received, but there are limitations which have emerged in the form of, I think, hallucinations. However, as Professor Rubin touched upon in his opening remarks, the rate of improvement that we've seen in relatively little time, I mean, less than 6 months, has seen a very low passage rate for the bar turn into one that is very impressive indeed. And I understand that this is matched by other standardized tests as well. And that's less than half a year. And here we think about 5 to 7 years. Why may we not reasonably assume that given the rate of progress, in that period of time, ChatGPT won't be in a position to, with much greater accuracy, do what lawyers are doing?
Thank you, Mr. Carlson. The reason is because because hallucinations are baked into the technology. The problem of hallucinations cannot be solved simply by controlling for the quality of the source data. Even Harvey, which my colleague referred to hallucinates. Now, while supplementing the model with better data might actually reduce the frequency of hallucinations, it will not completely eliminate it. And the reason is these models do not really comprehend what they're saying. They're designed to come up with an answer even when they can't find one in the source data. And so at least when we're speaking about large language models, we will always have the risk of hallucinations, and we will always need a lawyer to review the accuracy of responses. Now, I want to also bring up another limitation in the development of large language models to be applied in the practice of law. To be able to create bespoke or tailor-made research and writing tools, for example, we require massive amounts of training data. And that data also needs to be curated and labeled from scratch and tested so that the source data contains a reliable representation of the type of responses that we want the system to provide. As you can imagine, all of this is prohibitively expensive. And that is why legal tech companies today are building most of their products targeted at law firms on some form of existing GPT, such as, for example, GPT. So briefly to answer your question, even though we might see advances in the next 5 to 7 years with large language models, there will always be the risk of inaccuracy.
Well, let's just touch on that. I don't think that the standard is perfection, at least from the perspective of clients, right? And if an in-house counsel is given the choice between work product that is going to be, say, 96% accurate for pennies or 100% accurate for millions of dollars, I'm not sure that that's much of a choice. Is your submission here that it's nowhere near the point where we would expect the client to have to make that choice?
Yes, my submission is that at the moment, and what we see with current language models, we're nowhere near that point where a client would feel comfortable. And may I also add, lawyers would feel comfortable delegating that task to a large language model without being perhaps afraid that their professional responsibility might be compromised, alluding to the point that Ms. Morel, the Westgaver, made a few minutes ago. Now, let's remember that, of course, clients want efficiency gains. They want to pay lower legal bills, but they're also hiring lawyers. They're not outsourcing their legal work to an AI, at least not for the moment.
Not for the moment. Sorry, not for the moment, but perhaps the proposition could be put in through the prism of AI disrupting the legal profession precisely in that way. In that, at one point, we are in a service industry, and clients might come and say, "Do you know, on that question, I would trust the AI technology. Would you put that through them?" And I know, putting aside the ethical side of this, because we may have to have a long, hard look at this. I mean, is that not disruptive in itself? The fact that it empowers clients to say, we go to lawyers because we need a solution, but we also are able to choose the level of solution that we want to have.
Yes, absolutely. What I would posit is that that type of development is not necessarily revolutionary or sufficiently disruptive. I would equate that to, for example, what technology-assisted review has done for document review and document production. Now, of course, it has made the process a lot faster and easier and cheaper for clients, but we wouldn't necessarily say that it has completely disrupted the legal profession. We still need lawyers to review and tag documents. There isn't an AI program that can do this without any type of supervision from a human. And I would say the same standard applies to AI. Now, I'm not saying that we might not one day eventually reach the point where there is an AI that is so powerful that it can completely replace and displace lawyers and do legal work without any supervision. What experts sometimes refer to as artificial general intelligence. But what I would say is that we are nowhere reaching that point in the next 5 to 7 years.
Please carry on.
Thank you, Madam President. We can also another issue that I want to raise as a limitation that conspires against developing AI products that can disrupt the legal profession to the level that my colleague has argued, is that, as we know, AI can augment human biases at a massive scale. And here I want to refer to COMPAS, which stands for Correctional Offender Management Profiling for Alternative Sanctions Algorithm. This is a program that has been used by judges in the US to predict whether defendants should be detained or released on bail pending trial. And it was found to be biased against African American defendants. Now, imagine the kind of damage that these systems can unleash when done at scale. These biases can sometimes be obvious, as in the case of COMPAS, but many times they're not. They're difficult to identify and unearth. And finally, we cannot overlook the role that emotional intelligence and interpersonal skills play in our profession, which of course AI cannot replicate. And we know this from experience. Every interaction that a lawyer has with a client involves an emotional component. Client relationships are built on empathy and trust. They require putting yourself in your client's shoes. And judges and arbitrators do not decide cases purely on logic. Now, just imagine for a moment a child custody dispute where the judge needs to think about the best interests of the child, their specific needs, the child's relationship to their parents. Empathy plays a critical role in making decisions that affect others.
Counsel, if I could just come back to the point that you made before that one. I may be a little bit slow, but if you could just draw a line for the tribunal linking racial profiling in judicial sentencing to something similar happening in investment or treaty investment treaty or commercial arbitration. That would be helpful. I don't know how much weight to assign this point otherwise.
Certainly, Mr. Carlson. So an example of how biases could be replicated and augmented or exacerbated in an investment treaty arbitration context, for example, would be if someone develops an AI-powered tool to select arbitrators for a particular case. Now, if that tool is trained on the entire universe of publicly available investment treaty decisions, it is very likely that the results will be biased, and that they will be biased in favor of male appointees. And that is because factually, in the history of investment arbitration, there have been a lot more appointments of male arbitrators than female arbitrators. And so if there's no control for that bias that is inherent in the data, then the tool will also give a biased response. That just to give you an example of how that could, work, or how that could play out, for example, in the field of investment arbitration.
Could we, sorry, Council.
Sorry, Claire, please.
Could we fix this problem by limiting those tools to documents and information on the record of a case? Because that would be information that's arguably not biased. It's the documents on the record. So could an AI tool come up with a factual finding based on data that's been submitted by the parties on the record? Could that resolve the bias problem?
I mean, perhaps in some ways, yes, but in other ways, no, not really. Specifically as applied to the problem of creating this tool to appoint arbitrators, probably not, because still arbitrators on record are probably for the most part male and not female. But if we look at a tool that would be able to help with other tasks, such as, for example, helping decide a case, I would have to think about it, but I would probably say that it is still prone to biases, right? Because a lot of what is on record depends on how the parties present the facts, and there still might be inaccuracies that might need to be controlled in a way. Just off of the top of my head, I'm thinking again in the investment treaty context. There's a lot of differences between arbitral tribunals on standards that are of universal application, such as, for example, the minimum standard of treatment, FET, the most favored nation clause. There is like a very big divide between tribunals that, for example, say that the most favored nation clause applies to jurisdictional provisions. Others say that they don't. So, potentially by simply feeding this algorithm with a universe of existing awards and materials that are on record, you could still perhaps inadvertently be supporting one position on FET or on minimum standard of treatment or on any number of standards versus perhaps what could be considered a minority position. Now, this is something that requires human evaluation, right? We can't just leave this decision to a machine. I don't know if that addresses your concern.
You will have, again, having been interrupted massively, you have 2 minutes left for your remaining points. Thank you.
Perfect. Thank you, Madam President. I'll be very brief. Just 2 more reasons why the motion must fail. The first is that, as counsel on the other side admitted, lawyers and legal professionals are notoriously slow when it comes to embracing technological change. There are many examples. We've seen this with cloud computing that has existed since 1999, yet only now firms are starting to migrate their operations to the cloud. We saw the same with ODR, or online dispute resolution, which has existed since the 90s, and yet it took a decade, 2 decades actually, in a pandemic for lawyers to finally embrace ODR. And AI is no exception. And here I just want to cite a very recent study by Thomson Reuters on the use of generative AI, which found that 60% of law firms in the UK, Canada, and the US have no plans to incorporate any kind of generative AI whatsoever. And what is more, 62% of lawyers think that incorporating generative AI is inherently risky. So I don't really think that law firms are as eager to jump in on this technology as we think. And finally, and last but not least, there are economic forces at play that militate against embracing these technologies. Now, Ms. Tham referred to the billable hour. And I actually think that the billable hour is one of the greatest reasons why firms probably will not want to embrace this technology very fast. It makes no sense for firms to replace revenue-generating lawyers, junior lawyers with software. Now, eventually, it is true that clients might pressure law firms into adopting cost-saving AI, but firms will cling on to the billable hour model and resist this change for as long as they can get away with it. And that's, to sum up, members of the tribunal, advances in artificial intelligence will not substantially disrupt the practice of law in the next 5 to 7 years. They may bring about productivity gains, but we will not see the real disruptive potential of AI in our profession for many years to come. Thank you.
Thank you very much. Now we are going to move into the replies. Before we do that, and I apologize to everyone, I'm going to go offline for about 1 minute because I need to get my plug because my computer is running out of juice. So just give me 1 minute and I'll be right back. Right.
Sophie, you may be muted.
Apologies. Ms. Tham, we're going to move into your reply and you have 10 minutes.
Thank you, Madam Chairperson. Ms. Klot, in defending her motion that advances in AI will not substantially disrupt the practice of law, focused largely on the fact that artificial intelligence is, and I quote, inherently limited because it is simply nothing more than a productivity tool. I want to challenge that and note that productivity tools can substantially disrupt industries. Look at automated factories that have placed many people out of their jobs, self-checkout counters that have replaced cashiers. Simply because AI acts as a productivity tool does not preclude the fact that it can substantially disrupt the practice of law. Ms. Klot defined substantially disrupt as displacing work that can only be done by lawyers. And I submit that AI technology is displacing work that can only be done by lawyers, including reviewing contracts, conducting legal research and case law that previously was the sole domain of lawyers. And now part of that work is being taken over by AI technology. And again, as a profession that charges and is defined by the amount of time it takes to conduct the work that it needs to be done, this is a significant disruption to the profession because largely it creates a huge amount of new time and space that lawyers can then use to apply to specific skills and areas of their role that will be crucial in ensuring that the deployment of artificial intelligence and that sort of technology is done in a responsible, coherent, and ethical way. And limitations can be addressed and corrected. And if we are talking about it right now, it means that people are conscious of it, people are trying to correct it, and people will be aware of it. And I'm talking not simply about technical solutions to these sorts of limitations, but also regulations that I was mentioning previously. Ms. Klot mentioned inaccuracies. Arbitrator Carlson already mentioned that such inaccuracies can and will significantly be corrected in the subsequent more developed and more advanced generations of these technologies. Secondly, and as I mentioned before, the technology will be deployed as productivity tools in the sense that they are used as tools and not simply as replacements for us as lawyers. They will do the road work and we will do the review. Talking about human biases, I emphasize again that this motion is about whether AI advances will, not should, substantially disrupt the practice of law. The normative question is not at issue here. And to the extent we think that biases in the use of AI will deter users from adopting it in the practice of law, and thereby disrupting it, again, there are solutions through the use of high quality and diverse training data, processing and analyzing data to identify and remove inherent biases, controlling the data set that we're using. Again, implementing rules that ensure transparency and accountability that mitigate against this black box problem that Ms. Klot mentioned. Regular bias testing, ongoing education and training. Ms. Klot mentioned and discussed a lot the limitations to AI technology being able to deploy certain skills that are uniquely the domain of human beings, such as emotional intelligence, interpersonal communication skills. But I emphasize again, I think AI advances, I submit that AI advances will sufficiently change other aspects of the practice of law, sufficient to substantially disrupt it. I am not arguing here that AI technology needs to replace lawyers or decision makers. And even if one does consider that in order to substantially disrupt the practice of law, AI must also impact the adjudicative function. I submit that short of entirely replacing the decision maker, AI technology can be deployed in a way that will fundamentally change the role of decision maker. AI can help with piecemeal tasks that are helpful for the adjudicative process. Prediction analytics can be used to assist human judicial arbitral decision making by leveraging historical arbitration data and provide valuable insights into potential outcomes and likely outcomes. For example, in adjudicating on a request for bifurcation of a matter and having a better sense of the likelihood of the party objecting to jurisdiction succeeding on its objections.
Counsel, if I may, your learned friend spent a few moments touching upon the motion and the definition of substantial disruption. I'm still struggling a little bit to understand what you have in mind in relation to substantial disruption. I certainly appreciate that there are any number of ways in which AI may change the legal workplace, but where we draw the line is a little bit unclear. So perhaps you could sketch out for the tribunal what you think the law firm of the future looks like.
The substantial disruption, I submit, will come in the form of a substantially evolved nature of our jobs. Instead of spending 60 to 70% of our time, depending on our seniority in a law firm, instead of spending 60 to 70% of our time clicking through documents, reviewing case law one after another, suddenly our roles will be significantly changed in the way that it will be focused more on reviewing, verifying, strategizing, and deploying these transformative tools that will soon be at our fingertips in expanding the aspect of our job that machines likely will never replace and that can never be reduced down to probabilistic terms, whether it's in the form of text or not. And the elemental nature of that change in our jobs, whether as counsel in strategizing how to best advocate for a client, or as a decision maker, judge, or arbitrator in thinking about all the different aspects of a matter, the facts, the law, the equity, to the extent that that is relevant in deciding on a case. These tools are not meant to replace attorneys in the practice of law. The disruption will come in the form of the change of our roles and our skills. And that, I submit, is where the substantial disruption will come in.
Counsel, can I interrupt here? So this is a point about efficiency, and also the need to verify what the tool is going to do, make and produce. So you're saying that the practice of law will substantially change because people in law firms will no longer be reviewing case law and documents. You also said earlier that there'll be a need to verify and check, do some checks to understand, and literally check what the algorithm or the tool has produced. How do you reconcile that? Because do we not lose on the efficiency gains if we need to check everything that the machine produces? And so ultimately, is it not right that actually, lawyers might use those tools, but will spend significant amount of time, checking, making checks to ensure that their duties are, that they're satisfied that their duties to the tribunal, to the clients have been met.
I think that's exactly where transparency, accountability, and education and training will come in with respect to the deployment of these tools. I think in determining what to verify and what inaccuracies might arise and what are the risks that are associated with the use of specific technology will become clear when we ensure that there is transparency to the deployment of these tools. And if we know what data was sourced in and fed into the model, if we know how the model works, and if we know how the model generates its output, then we can, in a more targeted manner, conduct the verification process such that we do not lose those efficiency gains.
Please carry on.
Okay, so I just want to briefly respond to Ms. Klot's second and third point, which is the legal profession is risk averse, and that's why AI advances, they won't be adopted, and AI advances won't substantially disrupt the practice of law. My simple response to that is that they're already doing it. Law firms are hiring, are deploying AI technology in the examples that I've already mentioned. Ms. Klot said that the billable hour is the specific reason why law firms will not want to replace revenue generating lawyers, but clients will. But that's, excuse me, I misspoke. Firms will not want to replace revenue generating lawyers. That is exactly true, because they are how firms make their money, but firms also make their money from clients. And if there are no clients, then the firm will not be able to generate any revenue. And as I've mentioned before, these efficiency gains are so massive that it's hard to see why a client would be willing, after being made aware of all the risks and presumably the safeguards that will be built around the use of this technology on the part of law firms and counsel, why firms would not insist that why clients would not insist that law firms actually use this technology. And that's actually, in some ways, gives the client more value for their money, because the single billable hour will be used not so much for reviewing case law and documents and doing rote work, but actually performing the sort of strategic thinking and consideration that clients are paying their lawyers to do. Clients are hired.
If I can just chime in, I'm sorry to interrupt. I can't resist, because it's a great point. And my question is, frankly, isn't the real disruption of AI the fact that all of a sudden the lawyers who were used to doing the rote tasks that the AI will do much better than they, on your submission, will do much better than they are doing, they're going to have to start to think creatively and strategically, and that's the real disruption. I mean, how are they going to do that if they haven't been trained to do that earlier on? That's a rhetorical question, but if you wanted to address it, I'd be grateful.
No, thank you, Madam Chairperson, and that's a much more eloquent way of actually trying to explain what I've been trying to say, which is that because there will be this displacement of tasks on the part of lawyers and legal assistants by AI technology, suddenly it opens up all this time and space for lawyers to think creatively and deploy their skills as lawyers to those critical unautomatable aspects of their job. And there, when you think about it, then the possibilities are endless. And it really can enhance and develop the legal industry and thinking around the relevant issues of our time in a way that we never had before, because everyone was so bogged down in all these routine tasks that people had previously thought to be within the domain only of lawyers.
Thank you very much for indulging me. You have another minute if you'd like to conclude.
Thank you, Madam Chairperson. I would just simply want to summarize and say that the simple fact that artificial intelligence is inherently limited and simply a productivity tool does not prevent it from substantially disrupting the practice of law. And to the contrary, the fact that artificial intelligence can create and bring about such massive efficiency gains and support the legal industry in a way that can lead to new creative uses of these skills that lawyers must now carefully and usefully deploy, it will bring about a new era in the practice of law. Thank you very much.
Thank you very much. Ms. Klot, please, you have 10 minutes. You're muted, Ms. Klot, I think. We can't hear you. No, we cannot hear you, bizarrely. And you don't, there's no little icon saying you're muted either. I don't know if it's maybe something on your computer.
Maybe Ms. Klot is making an argument against technology nowadays. I will contact the supporting team.
It didn't sound like she expected this to happen, so.
Yeah, any spontaneous argument then.
Yeah.
See settings. Yeah.
Ms. Klot, please. please speak. Can you hear me?
Hello, can you hear me?
Yes.
Okay,
Yes.
perfect.
Fantastic.
Thank you. Excellent.
Thank you
Well,
very much. So
problem
you
solved.
have 10 minutes for your rebuttal.
Thank you. All it took was to change the settings, I believe.
Yeah, well, that's that's straight into our subject.
Exactly. Yes. Perfect. So thank you again, Madam President. I'd like to briefly respond to the points raised by Ms. Tham. First of all, Ms. Tham argued that simply because we are seeing, or AI in the short term will produce productivity gains, that does not mean that it cannot be disruptive or substantially disruptive. However, we have no real way to quantify those efficiency gains, not today, and we don't know if we will be able to quantify them in 5 to 7 years. The metric for this disruption through productivity is inherently vague. Now, Ms. Tam said that instead of spending 60% of our time clicking through documents, our roles will be significantly changed. But we cannot really put a number on it. How many hours will we save? We don't really know. Lawyers today certainly do not spend, I would say, 60% of their time clicking through documents, except perhaps during document review. And I would also challenge the assumption that most of what we lawyers do are rote tasks. But leaving that aside, we can actually look to the past and to the present to predict what can happen in the future. Now, the legal profession in the past has seen the advent of computers, of the internet, yet through all those technological changes at the end of the day, the legal profession has not really changed that much. Lawyers still deliver advice to clients in writing or orally. Lawyers execute transactions and analyze legal problems. They appear before human adjudicators. And at the center of it all are flesh and blood lawyers. And AI is no different. And let's remember that AI is not new to arbitration. We have been using machine learning translation and technology assisted review for years now. And most common legal research tools are also actually powered by some form of AI. If we think about it, before we could all do legal research online, lawyers actually had to go to physical libraries and peruse through physical court records. Now, while it is probably true that there are fewer legal librarians today than there were before, we wouldn't say that our profession has been significantly disrupted because we now have these new shiny research tools. Ms. Pham also referred to predictive analytics, doing piecemeal tasks, but AI has been doing this for a very long time, and no one has come out to say that these technologies were transformative. So I posit that anything short of a replacement of lawyers would not cause enough of a disruption, at least not in the next 5 to 7 years. Second, Ms. Tham also argued that AI is already doing work that can only be done by lawyers. She referred to reviewing contracts, assisting with drafting. However, while it is true that AI can assist with these tasks, AI cannot do this without the supervision and input of lawyers.
Counsel, if I could just chime in there, I think that opposing counsel's point, I don't want to speak for her, is not that there is no space for lawyers in the process. It's that there would be a substantial change in the amount of lawyers in the process. And so let's say that right now it takes 4 lawyers working full time for 3 weeks to draft a large contract and go through the motions in sort of the due diligence that would inform the underlying agreement. If we could do that in a matter of moments with 1 lawyer spending 4 hours on it, would you regard that as substantial transformation?
I would not regard that as substantial transformation, or not more substantial than other technological developments we have seen in the past. And that is precisely my point, right? But again, we go back to the definition of what we consider to be substantial. Is time saving substantial? Then how much time? Then again, we can't really say how much time these tools will save us because they haven't really been rolled out. We don't have enough experience with them. And on this point, I would like to go back to,
perhaps the natural tendency of lawyers to be cautious when it comes to embracing technological change, such that I don't really think that law firms and lawyers will be jumping to use these tools indiscriminately without first seeing how much time we're saving versus how what is our risk exposure. And I think that's really what this tribunal should look at here, right? I don't know if Mr. Carlson, if that addresses your question.
Please proceed, counsel.
Okay, thank you. So counsel on the other side also argued that there are ways to control for biases and address the accuracy problems that underpin current forms of AI. But even if that were true, it misses the point, because what is particularly troublesome about AI is not just that it has errors or that it replicates human errors, but it's the ability to compound and reproduce biases and mistakes at a much larger scale than a human can. And also, these errors and these biases are a lot harder to detect, precisely because we don't know about the algorithm's inner workings. Now, we can more easily correct and detect human biases and error. One might, for example, get a biased judge or arbitrator in a case, and we might bring that to light and use it to challenge said judge, for example. Or if there's a mistake in, let's say, a memo providing legal advice, a mistake made by a junior lawyer, we can go to that junior lawyer and we can ask them why they referred to a statute that is, for example, no longer in force. All of that is impossible, or at least not easy to do with AI. And the issue that we're facing is that the legal community and I would say the technological community still does not have a clear answer, a clear solution as to how we can address these problems that for lawyers create very significant risks. Fourth, simply knowing how the algorithm works is not enough. And this is because the logic of machines does not always follow the logic of humans. And I want to give a very specific example here. There is a product in the US called Lex Machina. It is mostly used in litigation, as I understand it. And this program can actually make predictions about how a case will be resolved with remarkable accuracy. But what's quite curious about this program is that it makes predictions looking at things such as, for example, who is the judge that has been adjudicated to a particular case or named on a particular case, what are the law firms that are involved, who are counsel appointed on either side. It does not necessarily look at the parties' arguments, at the law, and at their legal reasoning. It draws these correlations between seemingly random information to come to a solution. Now, the algorithm may be explainable and we might understand how it works, but we might not like the answer. Imagine parties to a dispute. I don't think that parties would be very satisfied and would consider a ruling as legitimate or a decision as legitimate when it can simply overstep the law, the parties' legal arguments. And finally, Ms. Tham argued that law firms are already embracing and using AI, and I would contest that. I mean, perhaps certain types of AI, sure, but generative AI, I wouldn't be so sure. And here I want to go back to the Thomson Reuters study that I cited earlier today, which shows that actually only 3% of firms in the UK, in the US, and Canada are using generative AI today. The data shows that firms still have considerable reservations about this technology, and we don't know if this is going to change in the next 5 to 7 years. Just to conclude, it is difficult to say that improved productivity creates substantial disruption. We have no way to measure that. AI can certainly aid in the performance of legal work, but it cannot replace human judgment, human expertise, and importantly, it cannot be held accountable. And this is unlikely to change in the next 5 to 7 years. Now, I remain available for any further questions you may have.
Thank you very much. Now, I can only bring this to a close and then ask, what are we meant to do at this stage? Are we giving comments? Are we opening the floor to questions? I'm in the organizer's hands.
I would say that it would be great to hear a decision on the arbitral tribunal. I mean, but I understand you might need to convene to issue a decision that is common for the three arbitrators. So it might be useful if you could first draw your comments, and then maybe from the comments that could lead you to a decision, perhaps.
Are you asking us to deliberate
Yes.
in public?
For academic purposes.
For academic purposes, I think that's
For
fair.
academic purposes, yeah.
I think that's fair. I think that's fair. I think let's. But
I have a question. If we can.
Sure.
If Madam President, I'm sorry, I have a question just arising out of counsel on the respondent side, just on the last point about law firms, embracing AI so far. Counsel, we talked about law firms, and we talked about the practice of law generally. On the in-house side, law departments in companies are extremely interested in AI. And one of the reasons why that's the case is that I understand that they think that they will be able to carry out tasks through the use of AI, which they used to instruct law firms for. For example, document review. Don't you think that in-house legal departments are going to embrace AI much earlier than law firms, and that as a result, the role of law firms, external counsel, will significantly change?
Yes, thank you for that question, Ms. Morel, the Westgaver. Yes, to answer your question, I would say yes. It's likely that in-house legal departments embrace this technology sooner than firms. And in fact, they're already embracing this technology earlier on through, for example, CLMs to manage contracts and automate templates for all sorts of agreements. Again, we're talking about, relatively routine agreements, NDAs, nothing too complicated, but of course these technologies have resulted in a lot of cost and time savings for in-house legal departments. So I would say yes, probably they will be more prone to adopting this technology. They're already doing it. However, whether that will result in a completely transformed role for the in-house legal counsel, I would probably say no. In-house legal counsel have to make very strategic decisions. Particularly, they have to act as business advisors, something that AI tools cannot do. They have to know the business really well. As to your question of whether that might result in less work for law firms, I would say yes, probably, arguably yes. It is difficult to say, though, at this juncture, whether that reduction in the work that is outsourced to law firms will be transformative enough. I think at this juncture, it would be a bit premature.
Thank you.
Fantastic. Right. Okay. I think now I can close the proceedings. And we're being asked to deliberate in public. So my colleagues, please, Mr. Carlson.
So thanks. Before I offer some thoughts, I'd just like to begin by way of an expression of gratitude to the organizers of the Stanford International Arbitration Association for putting on this wonderful event, and to the panelists for just a terrific job in engaging some very complex issues. I found this wonderfully educational, and was really quite impressed by the caliber of advocacy that you put forward. So my hat's off to both of you, and to Sophie for stepping into the chair role with virtually no notice and doing it with characteristic aplomb and grace. Thank you, Sophie. So perhaps I could just offer some brief points. Sophie, would you like me to cast a ballot at the end of that, or would you prefer that I just offer those views?
No, I think we're being asked to actually, yes, cast a ballot. So please go ahead and say what, any comment you have, and then where you land, and then I'll ask Claire to do the same.
Very good. Well, I'll begin by noting that I was sympathetic to the point brought on by Ms. Tham in her reply, that we've seen transformation take place with productivity gains. I had a similar reaction, and I jotted down in my notes before me, the internet versus the fax machine, the automobile versus the horse and buggy. Just because its productivity doesn't mean that it can't fundamentally transform an industry. And I do think that AI has potential to see those types of gains. I also am not sure that the baseline that we were thinking of when we're referring to the potential hallucinations of AI, in 3 to 5 years' time, if it means that just a fraction of what comes out of it is imperfect, that clients would still want to rely on paying the hourly rates that they do for external counsel. I think that based on the conversations that I have had with in-house counsel, there's a real possibility that even imperfect output, given its cost, could see widespread adoption. And that also made me a little bit reluctant to see there not being the type of disruption that could be introduced. I think the point about law firms being slow to introduce technology was a good one. I think the cloud computing example was spot on, but at the same time, as Ms. Tham raised, we've already seen that law firms are introducing ChatGPT-like systems. Harvey is one example, but there have actually been quite a few since Harvey that have been rolled out, although not nearly as well publicized. And I think that this is kind of going back to my last point, being partially in response to client interest. We ourselves at 3 Crowns have received inquiries from a number of clients already about how we would be responding to that. And I think that is prompting management teams at various law firms to really pay closer attention to this in a way that may not have been true with something like cloud computing. I don't know that many law firms were being prompted by clients as to when they'd be putting data in the cloud in mid-aughts. So all that being said, I actually side in favor of the opposition. And the reason why is this. In Ms. Tham's reply, she repeated on a couple of occasions that these tools are not meant to replace attorneys, just see a change in skills. If that's right, and if that's the baseline, I don't see that as prompting substantial transformation. Now, I'm not sure that I agree with it, but I can't sort of intercede my opinion on that here. So if that's the case that she's proving, and I think that she may have proven it, I think that when we think about the motion that's been put forward to the advocates, that this would see substantial transformation, I'm not sure that simply changing the skills of the attorneys involved in law firms constitutes substantial transformation of the practice of law. And on that basis, I side in favor of Ms. Klot in the opposition.
Thank you. Thank you very much for being brave enough to go first. Claire.
Thank you. I'm not sure I'm ready, and so
if you're not ready, then I can butt in. I can butt in and say that I have enormous sympathy for Ms. Klot, who had to argue my side of the proposition at Paris Arbitration Week against Claire, and it's a very difficult side to argue. Unlike Hugh, I think that Ms. Tham's framing of the disruption of AI to the skills, I think is a sea change to how lawyers are going to perform their job. and mostly how they're going to be trained. And that goes right down to the roots of what goes on in law school and in bar school, in order to be able to become effective prompt engineers, to free up, as she put it, the rest of their abilities, and to now whether that's going to bring about a more creative practice of the law, I would like to think so, but time will tell. The other thing that I will say is I noted, I think both sides, I think Ms. Klot was not disagreeing that there was substantial change in the offing, perhaps just not in the next 5 to 7 years. And I think that's a fair point as well. I don't think there was much difference between our two debaters. I also wanted to echo Hugh's point about the quality of the advocacy. I thought this was absolutely top class and extremely interesting and enlightening to hear. I just wanted to say very quickly that I apologize for this setup. I am in some dodgy hotel room in Zurich this evening, having talked about AI all evening at another event. And so this is why this is looking the way it does. So Claire, please, I hope you're ready now.
Yes. I was ready for my comments and my thoughts, by the way. It's just it's often when you deliberate, you just need to discuss. I think that's the point of deliberations. But I just wanted to, I guess, summarize and say that I'm attracted by the motion, the claimant side, simply because I do appreciate that the efficiency gain is going to be considerable, and we cannot underestimate that. Even though a lot of what we do is not just those mundane tasks, it's a significant part of it. On the other hand, I'm also attracted. I'm persuaded that, of course, we just not only do that, and there's still significant limitations to those tools. I'm a bit surprised that emotional, the human factor, as we call it in all those conferences, was not highlighted more, because I do think that as I said earlier, we have duties. We a lot of what we do as lawyers is to do with values, with respect, with care, and all those things. I think even ChatGPT recognizes that it doesn't, that those tools do not have those values. But so I'd like to see that a bit more, because I think that's understanding what makes us good lawyers, and what makes us stand out from the machines is going to determine ultimately how the profession will change as a result of the rise of those tools. It will determine if some of us actually, frankly, will survive. So I think somehow the result of at least my vote on the motion really depends on how what you consider, what kind of lawyer you consider to be. If you consider that your practice is mainly to review documents and read case law, maybe that's you will side in a different way than somebody who considers that their profession is actually being a trusted advisor, somebody who will always be there for the client, who will do their best and will argue a case with the utmost care, etc., etc. But in conclusion, I think actually I will argue. I think I agree with the motion itself. I think that the changes will be extremely deep and considerable. And I do think that in 5 years' time, if I adopt the Council for the Respondents Test, I think that in 5 years' time, we will look back, at least external counsel in international arbitration will look back at their role, 5 years in the before, and I think they will not actually really recognize what they used to do.
Thank you very much. I hope this is the deliberation that you were looking for. I don't know, maybe our council won't have feedback or reactions to the whole experience. I don't know if we have time for it. I'm again in the hands of the organizers.
Yes, we do. If I think that would be
I don't
great.
know if any of our advocates would like to comment on the actual session.
Sophia, would you?
Yes, sure. I'm happy to go first. So first of all, I also want to echo my thanks to the organizers, to Arbitration Channel, to the fantastic tribunal that we had today. You made our jobs really difficult. I have to say, during a couple of times I was like, oh my god. There was definitely a lot of nervousness, but I think it was like an interesting discussion. Frankly, for me, it was also novel since I tend to argue claimant side. So being put in the position of the respondent was a nice challenge. I actually enjoyed it very much. And on the motion itself, candidly here and not wearing our debater hats anymore, I would have to say I probably agree with the motion. I consider myself a technology optimist. I'm an AI enthusiast, and I would probably agree that we will see significant disruption in the next 5 to 7 years. All the more reason why it made my job a little bit hard, but that is what we do as lawyers. I also, I really agree with the point that was just raised by Ms. Morel, the Westgaver, on the human touch, the human element. I think that's something that will not be replaced by AI, and that in the practice of certain areas of law is critical. We could think about criminal law, family law, a number of areas of law where there are just certain tasks and certain activities where that human element takes precedence. Even in commercial law, I really think that the examples that were raised were very pertinent. The duty of care, being a trusted advisor. So then again, arguments on both sides, but candidly, I would probably agree with the motion. And I just want to thank everyone for a really, really interesting and enlightening exercise.
Ms. Tham.
Thanks. I like to essentially echo what Sophia said and thank this distinguished tribunal for the wonderful questions. It was a very hot bench, definitely kept us on our toes, but was very helpful in teasing out, I think, the critical points that are crucial to this debate. I personally am also on the side of the motion I was arguing, which I do not deny, I think made my life easier. I think since I also believe in it, I think that's also why my life was made easier, because I think the facts are on my side. Concretely, I did struggle, and I think Mr. Carlson, you raised a very right question of, I think everyone agrees that there will be change. Whether it will be substantial and whether it will be disruptive is another question. It was difficult to sort of define it. The practice of law is also extremely varied, and I think at the end of the day, how each one of us will be affected by it will depend on the nature of our practice, our seniority, and there's no doubt that the types of tasks that we foresee AI technology replacing for the moment are tasks that are for now typically performed by more junior associates, legal assistants. And what would that mean for their jobs? And I think it'd be a very fun thought exercise to think about. Would it mean that they're less hired? What would that mean for more senior folk? Would everyone sort of be undertaking tasks that are more strategic and that more senior counsel undertake at this point in time? How will that change the debate and the discourse in law firms? And in courtrooms and chambers? I think that's a really interesting question that I'm looking forward to seeing answered in the next years when this actually plays out.
Thank you very much. I mean, my closing point on Claire's point about empathy and humanity, I do worry and wonder in the rush to having an efficient, streamlined, cost-effective process, whether that comes at the cost of precisely that factor, and whether inevitably empathy, humanity, and the human touch has a time element that has to be paid for. It's an open question, and I think perhaps one for the next debate. I'm going to stop here and hand over to our organizer. Thank you.
Thank you very much to all of you. This was an amazing debate, incredible to watch. Very hard questions by the tribunal, but the speakers raised the challenge. So congratulations. It was really, really interesting. On behalf of the organization, I would like to apologize for the slight technological failures. I mean, my camera didn't work, so that's why you were seeing me from this weird angle. The slide presentation could not be shared. We had problems with audio more than once. So I think the conclusion from all of this is that we can only hope the technology does raise to the very high level of human capability that we have seen today. Thank you for all of you, and I hope to see you in further events organized by the association.
Thank you.